Are you and your significant other in a life partnership but not married? Now, recent changes to legislation could mean good news for you. I'm Simon de Benar and I'm a family attorney. The Maintenance of Surviving Spouses Act and Intestate Succession Act have recently been challenged, and the court rulings in both cases are good news for unmarried couples. The Maintenance of Surviving Spouses Act was passed in 1990 and allows the surviving spouse of a marriage to claim maintenance from the deceased estate if they are unable to provide for themselves financially. Such maintenance is valid until their death or remarriage. Now, life insurance or pension death benefits play a similar role, but not everyone holds these financial instruments. In determining the maintenance awarded to the surviving spouse, the courts have a duty to consider the heirs of the estate and their entitlement to inherit, as well as the spouse's standard of living during the marriage and capacity to provide for themselves in future. A woman who has been economically dependent on her husband throughout the marriage and is now past retirement age is unlikely to be able to enter the workforce. In the absence of any other provision in place, maintenance from the deceased estate can be a lifeline for a surviving spouse. Now, in 2005, this right was extended to same-sex partners in a permanent life partnership. However, heterosexual unmarried life partners were excluded. It took until last year for this omission to be challenged in the courts. An appeal to the Constitutional Court, Bayanya versus the Master of the High Court, found that all types of families deserve legal protection, whether married or not. Life partnerships confer a reciprocal duty of support. As a result of this case, all unmarried life partners, whether same-sex or heterosexual, can claim maintenance from their deceased partner's estate. Furthermore, the same ruling challenged the Intestate Succession Act. Intestacy, or dying intestate, is when you die without a will. The law makes provision for how your assets will be distributed if you have not expressed your wishes in a will. Previously, only married partners or same-sex life partners were entitled to inherit in terms of the Intestate Succession Act. This case now ruling gives the same rights to heterosexual life partners. I'm pleased that our courts have seen fit to update legislation to reflect modern practices. However, you should be aware that the amendments to these acts have not actually been promulgated. In other words, they are not yet law. For the time being, if you and your heterosexual partner are not married but view your relationship as permanent, it's a good idea to draft a cohabitation agreement to assert your standing as life partners and define the ownership of your assets. It's also important to have a will describing how you want your assets distributed after your death. For now, you don't want to risk dying intestate, or your partner could wind up with nothing. I can help you draft a cohabitation agreement or a will, or maybe you just want to gain a clear understanding of your rights in your particular situation. Give me a call on 086 099 5146 for a confidential discussion.